Hello, everyone. Good morning. Thank you for joining us today for our webinar. My name is Julie. I'm the Marketing Communications Specialist here at Church Casualty. And today we have with us Erick Becker, who is an employment law attorney, and Carla, Otte, who is a human resources professional. Both of them are part of our CCIA partners and CCIA advisory team. So they help our customers with their HR related questions and help customers navigate through the complicated California labor laws and employment laws, which we will be talking about today. So if you are a customer, if you are a Church and Casualty customer and you haven't utilized the Ask HR service, we encourage you to do so. It's a free service. You get free email access to Erick and Carla to help navigate any kind of HR related topics. So definitely check that out, and we encourage you to utilize that service. So before we get started, just want to remind everybody that we will be recording today's webinar as always, so you can refer back to it afterwards if you missed something or if you have a question, or you can share this with your team. So we encourage you to do that. And we will be doing a Q&A at the end of the presentation, but we will also be stopping periodically throughout the presentation to answer some of your questions. So if there's a question during one of the topics we're talking about, feel free to use the Q&A box at the bottom of your screen, and we'll try to get to as many of those as we can today. So Erick will be starting us off, so I'll pass it over to Erick.
Well, good morning, everybody. Thank you for joining this webinar. Carla and I have decided to tackle a very convoluted and confusing topic. So I want to start by just covering, in general, what we're going to be talking about in the webinar today. We're talking about the application of the various HR laws, both on the federal and the state level, to religious employers. And the reason why this is so confusing and convoluted is because there's exceptions or exemptions, whichever word you want to use, and kind of use those interchangeably a little bit, for religious employers. And the interplay between those exemptions is what leads to a lot of confusion. And the other thing I want to caution you is that in this area, while there's a fair amount of case law that defines these exemptions, there's a lot of areas where the cases have never come up through the courts, or we haven't had any guidance from the regulatory agencies, and therefore it's a little bit ambiguous. So you're going to have to bear with us as we go through this, because there's going to be some areas where it's not going to be black and white. And we're going to say it's likely that this is the case with the application to this particular law versus it's absolute black and white. So keep that in mind as we're going through this. Also, keep in mind that every employment-related or HR-related question that arises is always dependent on the facts. So while we're trying to provide you with some general information on this topic, as Julie mentioned, when a specific situation comes up, utilize the option of asking Carla or myself through Ask Legal or Ask HR about that, and we can give you more specific advice. I wouldn't want you to rely on general advice given in a webinar like this when you're dealing with a specific employee situation. So, and Julie, I just want to make sure that the screen is up. Yes?
Yeah, here, let me see if I can pass it over to you.
Okay.
It's probably easier.
All right. Very good. So, as I said, we're going to focus on the application of HR laws to religious employers. And I'm going to talk about how do we understand the two main exceptions that may, and I underlined and italicized may, that may exempt a religious employer from certain HR laws. So then we'll talk about how the exceptions apply to the major HR laws that you probably deal with on a day in, day out basis. Discrimination, leaves of absence, wage and hour. And then Carla's going to give you some practical guidance on handling some common employment issues that arise and taking into account these exceptions. What do you need to make sure that you have or you don't have in your employee handbooks, on your notices of posting with respect to labor and HR laws, on how do you deal with leave of absence requests and requests for accommodations and discipline and terminations. So we're going to try to give you some legal guidelines and maybe a framework on how to understand this topic, and then some practical guidance on how to apply it. So, as I said, there's two exceptions that may apply to religious employers. And I'm going to start by talking about the ministerial exception. You've probably heard this term before, and I want to kind of break it down to explain where that comes from and how it applies. So, when we think about the ministerial exception, what I want you to keep in mind is that this mainly depends on the nature of the employee, not the employer. Okay? So, while the ministerial exception typically applies to religious employers, and there has to be some sort of showing that the employer has some sort of religious focus, whether or not it applies depends on the employee. In other words, certain employees of a religious organization are going to fall within the ministerial exception, and certain employees may not. And you have to understand that the ministerial exception is not something created as part of any of the labor laws that we're going to be talking about, the HR laws that we're talking about. In other words, there's nothing, let's just take one example because we're going to be talking about it later. There's nothing in the Fair Employment and Housing Act, which is the California law that governs discrimination and retaliation and harassment, as well as other things. There's nothing in there that says there's a ministerial exception. If you're a minister, FEHA doesn't apply to you. Okay? This was created by the courts. The ministerial exception, and it's a relatively recent development in the law, but it's really something that the court said, look, you cannot have government stepping in and telling religious organizations what they're supposed to do with their employees who are ministers, because that interferes with the First Amendment and the free exercise of religion. So the ministerial exception applies depending on what kind of employee is involved. So employers under the ministerial exception have the right to make employment decisions about the ministers of their faith. So whether somebody works for a religious employer or not is not critical. What's critical in looking at this exception is whether or not the individual employee is acting as a minister of the faith. What does that mean? It's not limited to just clergy. Okay, the ministerial exception is not limited to just priests or pastors or rabbis or whoever. It's not limited to people who are ordained. An employee can meet the definition of a minister under the ministerial exception if their job involves conveying or teaching the faith. So, you can have, for instance, someone who is teaching at a school affiliated with the religious organization, and as part of what they teach to the students, it involves conveying the faith. That is somebody who falls within the ministerial exception, even if they're not ordained, even if they're not formally part of the church clergy. Same thing with musicians. The music is an integral part of the services, and they're part of conveying the faith. For instance, a choir director or a music director could fall within the ministerial exception. Now, of course, this is all very fact-driven, right? And a lot of the cases involve, looking at little nuanced pieces of the employee's job and the employer arguing, yep, that's part of conveying the faith, and of course the employee's attorney arguing, no, it's not, and these cases go up through the courts of appeals and sometimes even the Supreme Court in terms of whether or not somebody falls within the exception. But the important thing that you need to keep in mind is that the ministerial exception does not apply to exempt your organization entirely from the application of HR and labor laws. It is a fact-driven analysis depending on each employee. So where does this typically come up? This typically comes up when you have somebody who sues the entity for discrimination or harassment or some sort of wrongful termination. So if the employee is a ministerial employee, they fall within that definition, then it is a defense to say, look, we as the religious organization get to decide what we do with the people who are ministers of the faith, and therefore you cannot bring this discrimination, wrongful termination case. So the ministerial exception essentially prevents ministerial employees from suing when their organization takes some action against them related to their employment. As we'll talk about a little bit later, when it comes to wage and hour claims that I wasn't paid properly, claims that some sort of section of the labor code was violated, whether that's on the federal level or state level, the ministerial exemption can exempt the organization from being sued for those things. It depends on the nature of what is being alleged, as I'll talk about a little bit later. But you need to keep in mind that that it's not like discrimination and wrongful termination where it's an absolute exception. It's a pretty strong exception, the ministerial exception in wage and hour, but it's not absolute. But certainly if someone sues you because they're claiming they were wrongfully fired and they meet the definition, you should be able to exercise this exemption. Just trying to get to the next slide here. Okay, so here's the second exception. The second exception is for religious organizations. So this is an exception that depends on the nature of the employer, not the employee. To try to make this a little bit muddier, or hopefully maybe clearer, so you may fall within the religious organization exception and also have an employee who falls within the ministerial exception. Or you may fall within the religious organization exception as an employer and have employees who do not fall within the ministerial exception. So this is dependent on the nature of the employer. And that's where I think a lot of confusion comes from, because it's like, well, I thought the ministerial exception applied. Well, it may, depending on the employee, but even if the employee doesn't meet that requirement of being a minister, the religious organization exception can still apply. So, what is the religious organization exception? And before I talk about that, so what would be a scenario where an employee doesn't meet the ministerial exception, but you may be able to apply the religious organization exception? Common situation. You know, your church has a maintenance employee. They take care of the grounds. They take care of making sure that the church is clean, that all the rooms are clean, and they're directly employed by your organization. clearly they don't fall within the ministerial exception. Their job doesn't have anything to do with teaching or conveying the faith. But if they're working for a religious organization, then you may be exempt from some of these laws if they bring some sort of lawsuit. So, what laws are religious organizations exempt from? They're exempt from most federal discrimination laws. So, the big ones are, of course, Title VII, which deals with discrimination and retaliation and harassment on a federal level, and the Americans with Disabilities Act. So, both of those have carve-outs for religious corporations, associations, educational institutions, and societies. So it's a broad definition. Now, with respect to Title VII, however, it only exempts religious organizations from claims of religious discrimination, right? So if you're a religious organization and someone sues saying, hey, they fired me because I'm Hindu, and they said I couldn't work for this church, well, that would be exempted because obviously a church has to be able to just, when it comes to their employees, have them follow the tenets of the faith. But if, for example, the employee sues for racial discrimination under Title VII, that religious organization is not exempted. And then you'd have to fall back on the ministerial exception if it applied. But for purposes of the ADA, it is a much broader exception. So the ADA has to do with people who are disabled, and the ADA has a specific exception that applies to religious corporations and associations. So that's one exemption that applies. The second exemption is an exemption from the California Fair Employment and Housing Act, the FEHA, which is what most of the time in California we deal with when it comes to employees bringing discrimination or harassment claims. So the exemption from FEHA is a narrow definition. It's narrower than the exemption from the federal statute. So it's a religious association or corporation that is organized not for profit is exempt. So it has to be some sort of entity that is registered as organized not for profit to be exempt from FEHA. So if you have a general, let's just say, educational institution that has some sort of religious mission, but is not organized as a religious corporation and is for profit, they're not going to fall within this exemption. Now, unlike the federal exemption, the FEHA exemption exempts religious associations or corporations from all claims of discrimination, harassment, and retaliation. So, for instance, if somebody claims under FEHA that they were discriminated against based on sexual orientation, okay, if it's a religious association or corporation organized not-for-profit, that case goes away because that exemption is broader, even though the definition of who the exemption applies to is narrower. So, those are the two exemptions. Again, they can overlap, but the important thing to keep in mind for this religious exemption is it depends on the nature of the employer. If you're a church and you're organized as a not-for-profit religious corporation, you're exempt from FEHA, you're exempt from ADA, and you're mostly exempt from Title VII. So that's good news. And again, you also may be able to exercise the ministerial exception if the employee is a minister. So you have two bites of the apple in terms of your defense. But notice what the religious employer exception does not apply to. It does not apply to a lot of other laws that we're familiar with in HR. So this really, the religious employer exception focuses on discrimination and harassment and retaliation. So, for instance, let's just say that you have an employee who is not a minister and they sue for wrongful termination, or they sue for retaliation under Labor Code 1102.5, which is a whistleblower statute. The religious employer exception is not going to be a defense for you, because that exception only applies to discrimination and harassment under FEHA. It does not apply to wrongful termination. It does not apply to whistleblower retaliation. So it's not a full get out of jail free card. Okay, so I wanted to see, and we probably have a lot of questions. I'm going to go through this particular slide, and then we're going to stop for some questions that may have arisen regarding that distinction. But let me just talk about the application of these exceptions to some common HR laws. So, first let's talk about discrimination, harassment, and retaliation. As we've already covered, if the ministerial exception applies, you're completely exempt. So if someone asserts that they were terminated for a discriminatory reason or for a reason that is wrongful, you can assert the ministerial exception, and that is going to give you a complete defense. You are exempt from state claims for discrimination and harassment and retaliation if you are a religious organization, if you meet that definition like we just talked about. But we have to keep in mind that you may not be exempt from federal claims because, as I talked about previously, Title VII doesn't exempt you from all discrimination claims if you're a religious organization. Okay, so the religious exemption is a strong exemption when it comes to discrimination and harassment and retaliation. So let's talk about another HR law that we deal with pretty commonly, and that is pregnancy disability leave, or something new on the federal level, which is called the Pregnant Workers Fairness Act, which applies to employers that have more than 15 employees. And this is a new law that went into effect this year. So you've got pregnancy disability leave, which is a creature of the state law, and you've got the Pregnant Workers Fairness Act, which is on the federal level. So when it comes to PDL or PWFA, I'm going to throw some acronyms out there. If the ministerial exemption applies, you're completely exempt from having to grant leave due to pregnancy. So the ministerial exemption gives you a total exemption based on the First Amendment if you deny somebody the right to pregnancy disability leave. I know for most of you, you of course would grant somebody that leave, but it's not a legal right to that leave. So what about PDL? So PDL, under the FEHA, right, grants employees up to 4 months of leave when they're disabled due to their pregnancy. So, since PDL is part of FEHA, and as we talked about, if you're a religious organization, you are exempt, you would not have to grant that 4 months of PDL for someone who is pregnant because it's part of FEHA. Okay, well, what about the PWFA? Does that apply? So the federal PWFA does not have a religious organization exception. But unlike California PDL, the PWFA does not have a specific time frame that you need to grant pregnancy disability leave for. It just says you have to accommodate pregnant employees, and that accommodation may include time off if they're disabled due to their pregnancy. So if you have more than 15 employees and you don't fall within the religious organization, if you have more than 15 employees and you're talking about a non-ministerial employee, you may have to grant accommodations for their pregnancy disability under the PWFA. Whew. California pregnancy disability law, and we're going to be talking about that a little bit later, and how it intertwines with CFRA and FMLA, is already confusing enough. And now we've got this extra added thing, the PWFA. So again, to repeat, if you're talking about a non-ministerial employee, let's just say the office manager, and the office manager is pregnant and says, hey, I have to be off work because I have a disability. Here's my doctor's note related to my pregnancy. You may, in that situation, be required to accommodate that, even though you're not required to grant up to 4 months of leave under the PDL. Now, there's some practical applications of that we'll probably talk about a little bit later. Okay, I wanted to give Julie an opportunity to see what kind of questions we have and see if we can tackle some of these before we move on. There's just a bunch of chat questions that say, I'm hopelessly confused. Hopefully not, but we'll do our best.
Okay, let's see. So do ministers have zero legal protection from discrimination at the workplace?
So if we're talking about ministers, people who fall within that ministerial exception, then the answer is yes. The employer has the ability to make decisions regarding their employment, and they don't fall within the anti-discrimination provisions in either FEHA or in Title VII.
Murphy, can you check my mic? There's a couple of people who said they couldn't hear my question. Just make sure. Okay. All right.
Can you repeat that question? Sorry.
Yes. Let's go to the next one. Can an employee have ministerial exemption when the organization is not religious, like maybe a school?
Right. So that's a great question. So as part of the ministerial exception, you don't have to be a religious corporation like we talked about under FEHA to be exempt. But there has to be some sort of religious purpose for the institution. So if we're talking about a school, right, let's just say it's a private school, completely secular, no religious mission or aim whatsoever, then the ministerial exception is not going to apply, because the employee is going to have no part of their duties that is involved with conveying the faith. But if the school has a religious component to it, even if it's non-denominational, for instance, a Christian school, non-denominational, not tied to any particular institution, but as part of the curriculum is conveying the tenets of the Christian faith, then yes, a teacher could, depending on the facts, fall within the ministerial exception.
Okay. Does the FEHA exemption trump the federal exemption limits?
Does the FEHA exemption trump the federal exemption? So I think the general answer to that is no. Okay. To the extent that an employee cannot bring a FEHA claim in California state court for things like, disability discrimination or age discrimination or all of those other things because of the FEHA exemption, it kind of practically does trump the federal, because it's very unlikely. All right, let me see if I can put this in layman's terms. Plaintiffs' attorneys don't like to go to federal court. They like to go to state court. So if they're shut out of state court and they have to bring federal claims, they're probably not going to bring them. So hypothetically, if an employee works for a religious corporation and can't file a FEHA claim, they could file a Title VII claim as long as it's not religious discrimination, but they'd have to do that in federal court because it's a federal law, and most plaintiffs' attorneys don't want to do that.
Okay. Should we go one more question?
Sure, one
Is that
more.
Okay.
Yeah.
Okay. If the school is a ministry of the church, do they fall under these as well?
Okay. So, if a school is a ministry of the church, certainly the ministerial exception can apply to employees of the school to the extent that they are engaged in conveying the faith as part of their teaching, right? However, so let's talk about if the school is not a separate entity, it is one and the same with the religious corporation, a non-for-profit religious corporation, then the FEHA exception is going to apply. If the school is affiliated with the church, but it is not a not-for-profit religious corporation, then the FEHA exception may not apply. But, again, to get even more in the weeds, if they're affiliated with the church, even though they are not a non-for-profit religious corporation, the Title VII and ADA exception is going to apply because that's a broader exception, right? So it's I'm reminded of Shrek. It's like ogres and onions, layers and layers here. Okay.
All right. Let's go back to the presentation, and we'll get back to Q&A.
Okay,
in a little bit.
So got a couple more things before we turn it over to Carla. We want to talk about the FMLA and the CFRA. So the FMLA, of course, is the Family Medical Leave Act. It's a federal law that applies to employers with more than 50 employees. For many of you, you probably don't fall under FMLA because you don't meet that 50 employee threshold. But the California Family Rights Act applies to private employers if you have 5 or more employees. And these laws grant people rights to take leave if they're suffering from their own serious medical condition or they need to take care of a family member who is suffering from a serious medical condition. So how does all of this apply when it comes to FMLA and CFRA? So the ministerial exception, so for ministerial employees, likely they don't have FMLA and CFRA rights. Why do I say likely? Well, this is one of those areas where it's ambiguous. There's no case law that I could find that directly on point says, yes, the ministerial exception applies when someone's claiming FMLA and CFRA rights. My best estimate, based on prior Supreme Court precedent, is that if the case comes up, the Supreme Court would likely say, yes, the ministerial exception applies. But since there's no case, I can't say it for 100% sure. But in most situations, I'm going to say this applies. Okay. Now, what does not apply is the religious organization exception, because there is no exception under FMLA. And there is no exception under CFRA. So here's what's weird about the FEHA exception, okay? Because the CFRA is part of FEHA, but the CFRA exception for religious organizations only exempts them from the parts of FEHA that say certain unfair practices can be brought against employers. Let me put this a different way. So the part of FEHA that says that you can't discriminate against people, you can't retaliate against people, you can't harass people, and if you do that, it's an unlawful practice and you can be sued for it. That part, that's where the definition of employer specifically says employers don't include religious corporations. So religious corporations, not-for-profit, can't be sued for unlawful discrimination, unlawful harassment, and unlawful retaliation. CFRA is in a separate part of FEHA. So the requirement to grant people time off for a serious medical condition exists separately, and that part of FEHA only applies to private employers. It doesn't have that specific exception. So again, very confusing, but that's, I wanted to anticipate some question. Mm-hmm. Well, wait a minute, CFRA is part of FEHA, how come? And that's the reason why. Okay? So we talked previously about ADA, which is the federal disability statutes, but we also have, of course, state disability laws, which are part of FEHA. And the ministerial exception, once again, likely applies to ADA and state disability claims. There's not a lot of case law on that. Most of the ministerial exception cases have to do with people claiming discrimination based on sex or race, but based on the precedent, once again, I would say it's very likely that if someone is a minister, they can't claim disability. As I said previously, religious organizations are exempted from both the ADA and, if they're a religious corporation that's not-for-profit, from FEHA. So you couldn't bring a disability claim against a religious corporation. Okay. One more. Wage and hour requirements. Whew. This is where it gets really interesting in my world. Maybe not for you, but we talked previously about how all of these exceptions mostly come up within the context of somebody claiming they were discriminated against or they were wrongfully terminated. It doesn't come up very often in the wage and hour field. So when we talk about wage and hour, we're talking about, minimum wage, overtime, meal periods, rest periods, etc. So let's talk about the ministerial exception. The ministerial exception applies to FLSA, which is the federal labor law, which most of us in California don't worry about because, of course, the state has stronger requirements when it comes to overtime and meal periods and rest periods, etc. Whether or not the ministerial exception applies to state wage and hour claims is something that has not been litigated, to my knowledge, in any great detail. And so that's why I say in here, it likely applies to FLSA, but it's an open question whether it applies to state requirements when it comes to ministerial employees. So it's an open question whether or not, for instance, a teacher who falls in the category of a minister can bring a claim that they were denied meal and rest periods. Now, you also have, going to get even further down this road, you also have certain exemptions from the wage and hour laws, which you're probably familiar with. There's the managerial or executive exemption, there's the administrative exemption, and there's the professional exemption. And in California, you can be exempt from the wage and hour laws if you fall into one of those three categories, those definitions, and you earn twice the minimum wage. You earn a yearly salary of a little bit over $64,000 right now. So when we're talking about ministers will usually fall, when I say ministers, I mean clergy, within the executive exemption, professional exemption. So if a minister earns more than twice that minimum salary, or the minimum wage, so the yearly salary of $64,000 and change, they're going to be exempt, irrespective of whether or not the ministerial exception applies. But if you've got, for instance, a choir director who earns less than that minimum salary of $64,000 and change, they're not going to be exempt under the state law. They may be exempt as a minister, but that's going to be something that is probably going to involve a lot of litigation, so you need to be careful there. So that's where a lot of confusion lies too in this is, well, wait a minute, I thought ministers were exempt. Well, are you talking about exempt based on the ministerial exception, or are you talking about exemption based on their professional status? Those are two different analyses. So just keep that in mind if that issue ever comes up. So there's no exception for religious organizations under the federal Fair Labor Standards Act, but the Fair Labor Standards Act also applies to enterprises, and it's, again, an open question whether a church qualifies as an enterprise, because enterprise kind of means something that's designed to make money. But there's certainly no religious organization exception under the California wage orders or the labor code. So even if you're a non-for-profit religious corporation, you don't have any exemption from the wage orders or the labor code, all of those things that require you to pay minimum wage and overtime and all those other things. So the only thing that you may be able to rely on, and this is a may, is either exemption based on professional, administrative, or executive status, or maybe the ministerial exception, but that's going to be a long, bloody battle. Okay, so we're going to now talk about guidance on common HR issues. So I am going to turn this over to Carla, who is now going to talk about how all of this craziness applies to certain things that you face day in, day out.
Hello. That's really cleared it up.
I detect a hint of sarcasm there.
I don't know what to do. Okay,
Yeah,
here we
just
go.
press the button, it goes.
So I tried to pick out a few things that seem to come up a lot when we're talking with different religious organizations. There's some common themes that tend to run through. One thing is handbooks, so employee handbooks. And we want to make sure that we're not. So first of all, I want to say, just because we're not legally required to do something doesn't mean that it might not be the best practice to do it. So we may want to make a policy that is something that would be maybe required by law for somebody else, another employer, but we don't want to put things in our handbooks or in our postings that refer back to a law that we're subject to if we're not subject to that law. Because once we do that, now we've made ourselves subject to that law, and as a religious organization, we've given up that exception. So that's kind of the point of not putting it, or being careful about how we put things in our handbooks and in our postings. That doesn't mean you can't do it. That doesn't mean you can't give leave. That doesn't mean you can't accommodate a disability. It just means that we don't want to say subject to ADA and then give what you would do. So in handbooks, the places that this seems to come up most is, thank you. Oh, here I see. I just saw you clicking, so I just was lucky on that first one. We want to take care, so that's what I just said. The places I see this coming up most is in the introduction. There's always, if you use a handbook builder of anybody's, they're going to have that EEOC that says we are an employer that does not discriminate. And sometimes when we're using those handbook builders, we just put our name in and go, and now we've just said we don't discriminate and just gave up all of those exceptions to federal and state discrimination. So we want to make sure that we craft our statement. If you want a statement that talks about that at all, you want to make sure that you craft that in a way that says, we're going to discriminate against, on the basis of religion or whatever it may be. But you don't want to use just a template and put EEOC language into your handbook just because it's in the builder. So I see that a ton. The other place that it comes up is the leave policies, obviously, because especially in California and especially around maternity and pregnancy issues, there are so many already interconnecting leaves. And honestly, most of the time when I review somebody's handbook, it's got PDL in there. And the church isn't subject, the church or religious organization is not subject to PDL. So we want to make sure that we are not, again, that doesn't mean that you can't let somebody have off up to 4 months if they are having pregnancy-related issues. It does mean you don't want to put that in there and give up that exemption forever and for all time.
Yeah, and let me chime in real quick. I mean, one of the reasons why you don't want to have PDL language in there is because one of the things that comes along with PDL is the duty to continue medical insurance for the length of the pregnancy disability leave. And that may be a financial burden, And if you put the PDL language in there, you're adopting it, you're bound by it. If it's not in there, even if you grant that leave, you're not obligated to continue the benefits. So that's a good reason why.
The benefit thing.
Yeah.
So what I suggest is that, number one, be careful what you put in your handbooks. But that when you're sitting down, I would suggest that you make your leave policy decisions not when somebody's sitting across the table from you that's expecting and wants to know what her leaves are going to look like. And so you pull out the handbook and you're starting to read, and then it's like, wait, I just think maybe we're not I'm going to have to get some advice. It's really hard to do that when somebody's sitting across from you, and it's really hard to do that on you don't want to redo this decision every single time you have this come up. So I would recommend that you sit down and say, okay, these are the laws that we're subject to. So we know if we have over 50 employees, we've got a federal pregnancy law that tells us that we have to accommodate a disability that's caused by pregnancy. And we know that we have CFRA that would allow for baby bonding after the baby is born. So we know that's what we are required to do. Now, what do we want to do as our policies for our organization? And then craft your policies. Because you're not subject to those laws, like Erick was saying, that means that you won't have to continue the insurance benefits if you don't want to, but you can still grant the leave. So craft your policies when you're in an objective frame of mind, get those signed off on. That doesn't mean they have to be there forever. You can go back to them and make a different decision next year or when you review your handbook again. But you don't want to be making this decision every single time. That will help you guard against making a decision for that person, because I don't want to make a decision for you who we really value and then turn around and make a different decision for somebody else that you may say, well, we don't value as much, or we don't think we can do that. So you want your policies to be fair and equitable. So I think it's best to do that up front before, and then have confidence in that policy, because it is very likely that person has been on the internet and has looked up all of these leaves and will come in with these charts, and it is very likely that their doctor's office has even given them some stuff that shows them what leave that is available to them and what disability is available to them. And you're going to be in a position of saying, we're not subject to this, we're not subject to this. So you want to really have some confidence around, this is what we're subject to do, and this is what our church has decided to do in this area. And when I would say 9 times out of 10, leave comes up around some sort of pregnancy disability. And paternity. Remember, paternity is a part of all this too. So we don't want to wait until somebody said, my wife just had a child, what's your paternity policy? What is our paternity policy? So just want to be careful with that. Required notices and postings kind of go along with this. And I know it's really easy to order one of those posters from the Chamber of Commerce, and then everybody's happy, and it's got all 18 things on it. But remember, some of those 18 things, and right now it's 18, it could be different every year. Some of those things come from the Civil Rights Department, which is FEHA. And so you're not subject to those. You don't want to put that up on your bulletin board in your kitchen or your break room or wherever you post this, that here's your pregnancy disability leave rights, that you're not going to, follow because you're not subject to them. So we really recommend, and we do not have a poster for you. We even thought about putting one together once, and there's still things that each organization has to decide and this is not general enough. Even the posters I've seen that people have said, this is put together for religious organizations, you can poke holes in. There's either something there that I would say doesn't need to be there, or there's not something that, so you really have to do your own I don't think the composite posters are a good idea for religious organizations, in California especially. You really need to pick out your own notices, and you can order those just by the notice and pick out the ones that apply to your organization and post those. And you're just gonna have to do it that way. And that's, I mean, it's just not gonna be a giant poster. And so you just have to do that. But we can give you a list. You wanna pay attention where the source of the poster, the required posting is. And whenever it is fair viha, then you want to really look and see, are we really subject to that? Because that's the one that's really gonna be, that's the one probably that you're not gonna wanna put up. The other postings you might wanna not to put up are anything that requires you to post about unemployment. If your religious organization does not participate in unemployment, you don't wanna put up on your composite posting, here's how you claim unemployment when you don't even participate. Okay, that's it on that.
Here.
Do one more? Do you want questions or one more?
One less.
Okay. The request for accommodation. So this is, and this is something actually Eric and I just worked on something together on this. This is another one of those, okay, here's the law, and here's our employee, and what are we gonna do? And so I think that it's a comfort to know that, okay, we are not subject to all of this. We are, we do have some exceptions to this, but that also doesn't make it wrong to engage with your employee when they come in and they have a disability or something that needs to be accommodated. It's not wrong to sit down and look at what they need and accommodate that. That doesn't opt you into having to follow every ADA guideline that there is. And we want to make sure that we're, in the practical application of this, we're not just worrying about what's legal. We're also worrying about what are the optics like on this? How are we treating our employees? Is everyone being treated fairly? Is what we do for one, we can do for another? Just because we can't be sued for age discrimination doesn't mean we want to discriminate against somebody because of their age. Just because we can't be sued for harassment doesn't mean we want to harass. And so your church or your religious organization policies are going to have some of this in them anyway. It's just that there's not a law. So, you do want to, if somebody comes to you with a disability, and this is another one of those things, how do we handle that? Decide it beforehand so that when you get to it, you won't have somebody with their broken leg in front of you that you're trying to scramble and figure out what your policy is. And then you go to your handbook and somebody has used a builder and your handbook has ADA language in it. So then there you are. So you want to do this beforehand. You want to make sure your handbook backs up what you're going to do. And that way you can have with confidence, because again, they're going to be getting from Google and from their doctor and from their family, oh no, they have to accommodate that. And it may not be so. If you can't accommodate it because of your organization or because of your operation, then you can't accommodate it. But it's okay to still talk about it. So we want to take, when we're doing our best practices, we want to take everything into consideration, not just, well, we don't have to do that. So that doesn't mean you can't do it. Same thing with discipline and termination. So if you have somebody who is a ministerial employee, which we've gone over that, and you're sure they're a ministerial employee, we won't speak in the gray on that, but we're just sure there's a lot more leeway. I mean, there's no way around that. They don't have a lot of protection from law. So for other people, though, do remember there are still other laws that can be violated, and you can still have wrongful termination for your non-ministerial staff. And it's still best practice to have a progressive discipline system in your organization. Just because you can doesn't mean you should. And so it's still the right thing to do and the best practice to give people feedback, let them have a chance to improve. If you participate in unemployment, then you're going to want to do that for that system. But it's still, again, one of these things that here's our legal information. Let's take our other information too and bundle it together for our church policy or for our religious organization policy, because we're taking all these things into consideration and then implementing it. So to me, the legal aspect is one big aspect of it, but not the only. Okay.
All right. I'll take the laptop and we'll get to Q&A. Okay. Thank you everyone for submitting your questions in the Q&A box. And if we can't get to your questions, just a reminder that you can submit your questions if you're a customer to askhr@ccia.com. So definitely take advantage of that. Okay. Let's see here. Do religious organizations have different unemployment and SDI laws?
So in California, in some states, you can't even participate if you're a church or a religious organization. In California, you are allowed, you are not required to participate in SDI or unemployment, but you are allowed to opt in if you want to, if you are a religious organization. And if you are and you want to opt in, you can. And they always come together. You can't unbundle those two things. If you're going to participate in one, you participate in the other. So people sometimes want to participate in the program because they want the SDI benefits. The SDI benefits in California is a rich benefit. And it's an employee paid benefit, and it's a way to offer your employees, these rich benefits around leave and disability and paternity and family leave and all of that. So many religious employers opt in now. When you opt in, you can opt in for everybody, or you can opt in only for your non-clergy staff. So there's another fork in the road, even if you do opt in. But whatever you opt in for, and if you call it, if you opt in for your clergy, you call their housing allowance subject wages, they call it subject wages. So you can opt in for all of it for them, or some religious organizations only opt in for their non-clergy employees. But either way, you can opt in if you want. Once you opt in, you're in for 2 years. You can't get back out for 2 years. But you can. And I think sometimes it's a really good idea to look at it and see what it would be. The costs to the church are not great because you only pay the unemployment. But the benefits to the employees can be very, very good.
Okay. Let's see. Okay. If churches are not subject to FEHA, why are churches subject to laws regarding sexual harassment in California and the training?
I was wondering if this would come up. Okay, so remember when I talked about how the religious corporation exception is in that part of FEHA that talks about unlawful discrimination, harassment, and retaliation, right? And how that exception only applies to that particular section of FEHA. So the sexual harassment training requirements are in a different part of the FEHA. And so even though religious corporations would be exempt from FEHA with respect to unlawful acts, they're not exempt from the training requirement, just like they're not exempt from CFRA. But the sexual harassment component is part of the unlawful acts. So religious corporations have exemption from employees bringing sexual harassment, not necessarily from parishioners or people who attend the church from bringing any type of harassment-related claims, because those are different laws.
Okay, we have some time for one more. We had a couple people ask about the policies to post in regards to the labor law posters. Is there a place where they can find those or verbiage on where they can find those policies to post? Is that something that we can provide to them, or
We can send them.
we can send that? Okay, perfect.
Yep, we put together a chart on that.
Okay. Okay, and then one more, and then we are good to go. I had the verbiage on the religious. Where would I find verbiage about religious exemption for ADA and FEHA? Is that kind of the same?
This is all part of the statutes. So you have to basically go on the Google machine and the exemption, the exemption under FEHA is at, I think it's 12962, 12962D, I believe, of the government code. So FEHA is in the government code. The Americans with Disabilities Act is a federal code. You basically find that by finding that section of the code.
Okay. All right. Well, thank you everyone for joining us today. Thank you, Eric. Thank you, Carla. And we'll see you guys soon.
Thanks, everybody.
All right. Take care.